Oh, come on. They charge him with theft because he's trying to charge his phone.
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him. Charging his cell phone, so they come up to him and they start talking to him and then, all right, come on up. Hi, Alan. Tell me, what's up?
If we could get PC for Samuel Duto.
Shh. Okay,
I wanted to see if we could get PC for Samuel Duto.
okay, sure.
We are on September 13th.
Okay, hold on. Just way too loud. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
Okay.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven. And the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out, they noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under penal code.
Oh, come on. They charge him with theft because he's trying to charge his phone.
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him.
Yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what, so they go up to him, they start talking to him,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he stated his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
Defendant had outstanding warrants and was placed in custody.
They
He was charging his phone.
what do you think? Charging his cell phone, so they come up to him and they start talking to him and then, I mean, come on. Do we need help back there?
No, nothing treats you better.
You all right back there?
Yeah, he's fine. He's just upset if he wants to go now. He's not getting his way.
Who is it?
I don't even know him. The attorney told him he was done, but I don't know about it.
Okay.
Tyler? Probably. No, it's not. Let me see.
Talk to Pavel, let's see.
Judge, we would, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft.
I mean,
So
the way it's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest. I mean, that's.
do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
Because it might happen anyways.
I
You know
wanted
what I mean?
time served. I wanted the time served. He offered, he would have had to do 24 more days.
I'm okay with that, or I'm okay with whatever you want.
Okay.
It's up to you guys.
Yes, Your Honor. I'll always defer to Pavel with things. After 90 days, depends once time served.
Yes.
Okay, and I'm totally fine with that too.
Okay, thank you.
All
right,
thank you.
We'll came up. Thank you.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
Doing all
new?
right.
Yes.
It's Gaston.
I'm right. Thanks. Good morning, Mr. McCaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mr. McCaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say it. Okay.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything
odor.
else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McCaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand
It's
this.
just
I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right. No, I'm going to find no probable cause, Mr. McGaskey. It's very possible that they take it to a grand jury and indict it. But so I would be on the lookout. Number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm going to find no probable cause. Just take a seat for a moment.
Thank you, Judge.
Thank you, Mr. Jeff.